It's that aha moment, right? That flash of genius when you solve a problem, when you create something totally new. It's an incredible feeling. But then, after the excitement cools down a little, this huge question mark pops up. Okay, what do I actually do now?
And that's really the heart of it, isn't it? How would you take this brilliant thing from just being an idea in your head and turn it into something real, something that's legally yours, and something that could be incredibly valuable? Well, that's exactly the journey we're going on today. So let's dive in. All right, so before we even think about filling out a single form, the very first step is to put on your business hat. How is this invention actually going to make money? And that brings us to a really important word: commercialization. So what in the world is commercialization? Well, think of it this way. It's basically giving someone else permission to take your invention and run with it. Maybe you're the idea person, but you don't have a factory or a sales team. Commercialization lets you license your patent to a company that does, and they'll handle all the making and selling based on a deal that you both agree on.
When you decide to license, you've got two main flavors to choose from. On the left, you have an exclusive license. This is like giving the one and only key to your invention to a single company. Nobody else can touch it, not even you. Then, on the right, there's the non-exclusive license. This is more like making a bunch of copies of the key. You can give them out to as many companies as you want. Which one's better? It's not a legal question. It's a business strategy question.
Now, here's something you really need to know. A patent isn't just a trophy you hang on the wall. The whole point of the patent system is to get new ideas out into the world. So if your patent just sits there gathering dust and isn't commercialized within 3 years, well, someone else can actually go to the controller of patents and ask for what's called a compulsory license. That gives them the right to use your invention. So having a plan to use your patent isn't just a good idea, it's essential.
Okay, as you can probably tell, this whole world of licensing and deadlines is, well, it's complicated. You wouldn't try to climb Everest without a guide, right? And you definitely shouldn't try to navigate the patent system all by yourself. And that's where a patent attorney comes into the picture. So what's so special about these experts? Well, for starters, they live and breathe patent law. But just as important, they have the technical chops to actually understand what your invention does. They know how to write up the application in the super specific legal language required, and they'll be your champion, your representative through the entire process. They are a critical team member for sure.
So you've got your expert guide on the team. The next huge question you have to answer is where? Where in the world do you want to protect this invention? This gets us into the whole idea of how patents work geographically. And this is probably the number one question inventors ask. It just makes sense, right? You have one invention, so you should be able to get one single patent that covers the entire globe. But the reality of how things work is a bit different. And the short answer is a big, fat no. There's no such thing as a worldwide patent. A patent is territorial. That means it only works in the country where you applied for it and got it approved. Think of it like this. A patent is a national key, not a global master key. You need a different key for every country where you want protection. Okay, so for all of our inventors who are residents of India, this leads to a really important logistical question. If you've got your sights set on protecting your invention in other countries, where do you start? Do you have to file in India first? For residents of India, the rules are very clear. Yes, you have to file in India first. Once you've done that, you have to wait 6 weeks before you can start filing in other countries. The only way around this is to get special written permission from the controller of patents. It's a procedural step you absolutely cannot skip. All right, so business strategy? Check. Legal guide? Check. Geographical plan? Check. Now we get to the really fun part, the paperwork and the costs. Let's take a look at what you'll be filing and what it's going to cost you. This chart gives you a quick snapshot of the official fees. And you'll notice right away there are different price tiers. The costs are lowest if you're an individual inventor or a startup, a bit more if you're a small entity, and the highest for big companies and others. You've got your initial filing fee, then a bigger fee when you ask them to actually examine your application, and after that, you've got renewal fees to keep the patent alive, and those get more expensive over time. So yeah, it's definitely a financial commitment. Next up, you'll mainly see two types of applications. The ordinary application is just what it sounds like. It's your first filing straight to the Indian Patent Office. But the convention application is a really powerful strategic tool. See, if you file in what's called a convention country, you then have 12 months to file in other member countries, and you get to claim the date of that very first filing. This is a huge deal because it locks in your invention date worldwide and protects you from anyone else who comes along with a similar idea after you've already filed. As you go through all this, you're going to hear a bunch of jargon and specific terms thrown around. To navigate this world, you gotta speak the language. So let's quickly break down the key players you need to know.
First up, the inventor. Super simple. That's you, the brilliant creator of the invention.
Next, the applicant. This is whoever actually files the application. Now, this could be you, the inventor, but a lot of the time it's the company or university you work for. Basically, the inventor creates, the applicant files. Once the patent is officially granted, the owner is called the patentee. This is usually the applicant, and now they hold all the legal rights. And finally, the assignee. A patent is a piece of property, which means you can sell it. The person or company that buys it becomes the new owner, and they are known as the assignee.
So who are the referees in this whole game? Who manages the system? And what happens if your invention is more of a clever improvement than a massive, earth-shattering breakthrough? Let's meet the key organizations and look at a pretty cool alternative to a full patent.
In India, you've got a few main players. The IPO and the CGPDTM are the big government bodies that handle the day-to-day of processing and granting patents. Then you also have organizations like TFAC, which is kind of a technology think tank, and the NRDC, which does the crucial work of helping get inventions out of labs and into the marketplace. Now check this out. What if your invention is a smart improvement, but maybe not a giant inventive leap? Well, many countries offer something called a utility model. You can think of it like a patent light. The rules aren't as strict, it's cheaper to get, it gets approved way faster, and it still gives you real protection, just for a shorter amount of time. It's a fantastic option for those smaller, clever innovations. So, there you have it. That's the roadmap. We've gone all the way from that first spark of an idea to a fully protected asset. We've talked business strategy, getting legal help, where to file, and even the nitty-gritty of the paperwork. Your idea is the starting line. The path is laid out in front of you. So the only question left is, what's your first step going to be?